Start. Having rejected the aforesaid two preliminary objections raised by the appellant, the question that now remains to be examined is whether, in the facts of the present case, the respondent could have invoked arbitration after having signed the consent letter and the advance discharge voucher. Stop para. A contract between parties can come to an end by the performance thereof by both the parties, that is, by the fulfillment of all the obligations in terms of the original contract. Stop. This is referred to as discharge by performance. Stop. Alternatively, the contract may also be discharged by substitution of certain new obligations in place of the obligations contained in the original contract, and subsequent performance of the substituted obligations. Stop. The substituted obligations are referred to as accord, and the discharge of the substituted obligations is referred to as satisfaction. Stop. It is referred to as discharge by accord and satisfaction, or by full and final settlement in common parlance. Stop para. A written confirmation of discharge by accord and satisfaction can also be in the form of a full and final discharge voucher, or a no dues or a no claims certificate issued by one of the parties acknowledging that there are no outstanding claims and that such a party has received the full and final payment to its satisfaction. Stop. In the insurance sector, the general practice is that the insurer obtains undated discharge vouchers from the insured in advance by making the insured to sign on dotted lines before processing the payment in respect of the claims of the insured. Stop para. No matter what, where the respective rights of the parties inter se, they are abandoned in consideration of the acceptance by all for a new agreement. Stop. The consequence is that when such an accord and satisfaction takes place, the prior rights of the parties are extinguished. Stop. They have in fact been exchanged for the new rights, and the new agreement becomes a new departure, and the rights of all the parties are fully represented by it. Stop. As discussed in the preceding paragraphs, the appellant has contested that once a full and final settlement was arrived at between the parties, the insurance contract between the parties could be said to have been discharged. Stop. Once the contract stood discharged, it was not open to the respondent to resile from the settlement and invoke the arbitration clause, as no obligations remained to be fulfilled under the contract pursuant to the discharge of the contract. Stop.